Good morning, everybody. Sabrina and I are here today to talk about subscription contracts. Subscription contracts are all the rage at the moment. If, like me, you spent your Christmas catching up on the final season of Stranger Things, you're going to pay a monthly fee to Netflix for the privilege. But multiple other TV streaming services, and with a consequential monthly cost, are available. If you have a mobile phone, you likely pay your monthly bill by way of a recurring monthly payment. And if you started your new year with a new fitness regime, you may well have a gym membership for which you again pay a monthly fee. Just to give other examples from my own household, I think that we've got subscription contracts for flowers, both reading and audiobooks, cooking ingredients, comics, broadband, cloud storage, computer games, various insurances, music, and my personal favourite, which is a wine subscription.
Some of these, such as mobile phone contracts and contracts for financial services, are already subject to their own sector-specific regulation. But in the unregulated sector, it is thought that there are as many as 155 million active subscription contracts in the UK,
costing in total upwards of £26 billion a year. Of these, it is thought that there may be 10 million, amounting to 1.6 billion a year, that are unwanted. Consumers either don't realise that they have them, or have inadvertently been moved onto a recurring payment plan from which it is difficult to escape. At present, there are no specific safeguards aimed at subscription contracts. Consumers will get certain pre-contract information and an initial cooling off period as a result of the Consumer Contracts Information Cancellation and Additional Charges Regulations 2013, but there is nothing directly targeted at subscription contracts. That is due to change, with Part 4, Chapter 2 of the Digital Markets, Competition and Consumers Act 2024 introducing regulation directly targeted at subscription contracts. However, one key question is when these provisions are going to come into force. Whilst other parts of the DMCCA are already in force, the subscription contract regime is not. It was originally thought that the provisions would come into force early this year, but that now appears unlikely, given that we're still waiting for both secondary legislation and CMA guidance on their meaning and implementation. And the latest indications from the government are that the provisions will not now come into force until autumn 2026. Today, we're going to spend some time looking at what the new regime will look like. Sabrina will set out what are the main effects of the current primary legislation, and then I will spend a little time at the end looking at what we might expect to see in the forthcoming secondary legislation and what businesses can do to prepare now. And with that, over to Sabrina.
Thanks, Simon. So what do the new provisions do? Well, the starting point for that is what is a subscription contract. And a subscription contract is a contract between a trader and a consumer for the supply of goods, services, or digital content in exchange for payment by the consumer, so free subscriptions are excluded, which is one or both of a specified type, and we'll come back in a minute to what is meant by a specified type, which is not excluded. And those exclusions generally cover contracts that are already subject to sectoral regulation, so your regulated utilities contracts, insurance, financial services, and then prescriptions, property rental agreements, childcare, etc. But in summary, if a business relies on renewal by default, the DMCCA regime will need to be considered. So what are the specified types that I mentioned a minute ago? Well, there are two, and I'll call the first type 1. That is a contract that contains terms providing for the following. First, the automatic renewal or continuing of the supply of goods, services, or digital content for an indefinite or fixed period. Second, for the consumer to automatically incur liability for each supply or recurring liabilities for the continuing supply. And finally, a right for the consumer to bring the contract to an end. So it doesn't apply to contracts that terminate by default, and it doesn't apply to contracts with no termination rights at all. But of course, those would be vulnerable to the unfair contract terms regime. So it's a relatively broad definition, and it includes, for example, a 12-month contract that renews annually unless cancelled, so your boiler servicing contract, and monthly subscriptions with no end date unless cancelled, so the gym contracts that Simon mentioned. Type 2 then is a contract that contains terms that provide for the following. First, the supply of goods, services, or digital content to a consumer free of charge or at a specified rate for a period specified in the contract. The consumer becomes automatically liable for payments or payments at a higher rate for supplies after the discount period, including if a trader has the option to impose a charge or a higher charge, so no higher charge actually has to be applied. And finally, a right for the consumer to bring the contract to an end before such liability is incurred. So examples there are free subscription to the Times or Disney Plus for 4 weeks, moving thereafter onto a paying contract, or an introductory lower rate to meal prep service, followed by full price thereafter. But the key point here is it's a subscription contract from day one, not when you first make payments. So what are the consequences of being a subscription contract? Well, once a contract falls within the regime, the kickback information and right to cancel regime are disapplied, and there are 5 categories of a new legal consequences that follow. And that's where the risk and the work really starts. First, pre-contract information. Prior to entry into subscription contract, and as close in time to entering into the contract as is practicable, the trader must first give, and I emphasise that, the key pre-contract information. And that's a significant change from the kickback regime, the contents of which are listed in Part 1 of Schedule 23, and depends very much on whether you're a Type 1 or Type 2 contract. But it includes the amount a consumer would become liable for under each month if the payments under the contract fell due monthly, the minimum total amount for which the consumer will become liable for under the contract, etc. But that information must all be given together, and it must be separate from the full information and any other information. And second, a trader must give or make available, so slightly different there, the full pre-contract information. And that's listed in Part 2 of Schedule 23, includes the key pre-contract information and other listed information which broadly reflects the kickback requirements, and includes a consumer's reminder of their statutory rights under Part 1 of the Consumer Rights Act, so that's the right to reject, etc. It must be given or made available together, but there's no need to provide the additional information if it's apparent from the context. There are other requirements that relate to the mode of giving, so whether in writing or orally, and for subscription contracts entered online, which of course are relevant to the design of the consumer journey. Next, reminder notices. So these are reminders of the consumer's ability to cancel. They're new obligations beyond those seen in kickback. The form and content are in Part 3 of Schedule 23, but they must be sent to remind the consumer of their right to cancel. After the end of the minimum term or fixed period, after the end of an offer period or free trial, or otherwise every 6 months. As for the timing, the notice should be sent before the payment that the customer has the ability to cancel. So if you have a 3-month free trial, it must be sent before the payment that's taken relating to the 4th month, then in advance of the 6th monthly payment thereafter, so in month 9, for example. We then move on to how far in advance does that notice have to be sent. Well, it must be in the period specified in the pre-contract information, and that must be reasonable for the purposes of informing the consumer that they will soon become liable for payment, and reasonable for the purposes of enabling the consumer to cancel. So there is a degree of discretion to traders there. And it can be sent alongside other material, so long as the prescribed information is more prominent. So potentially an opportunity there for marketing at this stage. There are then additional notice requirements for subscription contracts that renew to a period of 12 months or more. There needs to be an additional reminder notice prior to the one that we've been discussing, but we won't get into that today. Third, rights in respect of the end of the contract. The trader must make arrangements to enable the customer to cancel the contract, firstly in a way that is straightforward, and secondly without having to take unnecessary steps. Examples of these cases are provided in the explanatory notes of practices that are likely to breach this provision. So for online contracts, an example is given of making the process to exit more onerous, so requiring a phone call, or failing to provide clear and prominent options to turn off auto renewal. And if a consumer does bring a contract to an end, the trader must give notice of this, acknowledging the cancellation, called an end of contract notice, and that must comply with the form and content requirements, and then refund any overpayment. Next, implied terms. So in addition to the terms that are implied by the Consumer Rights Act, You also have implied terms that the trader complies with their pre-contract information obligations, the reminder notice obligations, and end of contract obligations. And finally, cooling off periods, in which there is a right to cancel. So you've got the two different periods. Your first of the initial cooling off period, which is 14 days from receipt of the first supply of the goods or the beginning of the contract. And that regime is similar to the one that you'll be familiar with in KICAC, but now includes on-premises contracts. And second, you have the renewal cooling off period, which is entirely new and runs for 14 days from the end of the concessionary period. So when the supply is at a free or reduced price, or 14 days from the beginning of a further 12-month or longer minimum or fixed term. And in respect of the renewal cooling off period, the trader has to give the consumer a cooling off notice, in effect reminding them of their right to cancel. That notice must be provided on the first day of the renewal cooling off period or as soon as reasonably practicable thereafter. So if you have recurring monthly payments where you can cancel any time, you have your initial cooling off period but no renewal cooling off period. If you have a 3-month initial free period, you have an initial cooling off period, then a cooling off notice in month 4. If you have a 12-month fixed term, which renews each year automatically, you have an initial cooling off period, then a cooling off notice in month 13, 25, etc. So it very much depends on the circumstances. But what happens if you get it wrong? That depends on the non-compliance in particular, but it includes a consumer not being bound by the contract, the right to cancel the contract, and the explanatory notes give examples where this arises, so where you obscure the pre-contract information by including additional information that's not prescribed, where you fail to provide all the prescribed information in a reminder notice, where you fail to comply with the rules relating to timings for reminders. And these examples very much demonstrate that partial compliance is not, in the drafter's mind, full compliance or compliance at all. You have commission of criminal offences similar to KICAC, commission of unfair commercial practices under the DMCCA, and of course it may be a trigger for the DMCCA court enforcement regime or the CMA direct enforcement regime. So it's quite draconian consequences, demonstrating the importance of getting it right.
Thanks, Sabrina. Well, now it's over to me to consider what we might see in the secondary legislation, what we might see in the guidance that we're expecting from the Competition and Markets Authority in due course. We know from the DMCC itself what areas we can expect to see the secondary legislation cover. We have the benefit of a government consultation published at the end of 2024, which gives some indication of what we can expect. Whilst the proposal and the consultation, of course, not set in stone, they do give a flavour of what the final regulations might look like. First, the DMCC is currently silent on what should happen if a customer exercises their right to cancel. So it leaves the practicalities of how this should actually work in practice for the secondary legislation. So we can be confident that the regulations will in some manner provide for what should happen, although the devil may be in the detail. The consultation recognises that in many subscription contracts, traders will have provided goods, services or digital content during the term of the contract, and it adopts as the starting position that if there is cancellation by the customer, well then the trader shouldn't be out of pocket. The consultation therefore proposes a regime broadly in line with the 2013 Consumer Contracts Regulations, albeit with modifications reflecting the fact that these are subscription contracts, and hence goods, services or digital content may be supplied periodically, and that cancellation may occur at the renewal stage rather than at the time that the contract is initially entered into. For example, it's proposed that with goods, the consumer can return goods received during a cancellation period, but not before, and can receive a refund subject to any deterioration of goods due to handling. And certain types of goods can't be returned, such as perishables, bespoke goods, or unsealed healthcare products, which has been mentioned earlier, and hence any refund to a customer would reflect that. For services, again, we've got a sort of provision similar to the 2013 regulations. It's envisaged that any refund will be pro rata for the service provided, as long as the consumer's express request is obtained to performance during the cooling off period, which mirrors similar provisions in the 2013 regulations. And for digital content, however, the position is a little different, because here the consultation proposes 3 options, although the final of these, which is disapply the cooling off provisions altogether, is discounted. So out of the other 2, there's more of an open question as to what will be adopted. These are whether the customer receives a pro rata refund in the event of cancellation in a similar manner to services, or alternatively whether the customer loses a refund for which specific digital content which has been supplied in the cooling off period at the customer's request, and that's in a similar manner to how the 2013 regulations currently operate. Second, the regulations are likely to provide for an extension of both the initial and the renewal cooling off periods if the trader does not comply with the relevant information provision requirements. And it's proposed that they are extended by 12 months in line with the approach in the 2013 regulations. And as well as the sanctions that Sabrina set out, this is therefore a further sanction for non-compliance. If you get your information requirements wrong, the customer gets a longer cooling off period. And it's therefore important for traders, therefore, that the information notice correctly reflect the statutory obligations. Third, the regulations will provide for how refunds are to be made upon cancellation, and the proposal in the consultation is that refunds should be provided 14 days from cancellation, or if goods are to be returned, 14 days when the goods are actually returned, or when the customer provides evidence that they've sent them back. So in this respect, if the goods go missing in the post, the risk is on the trader. Fourth, the regulations are likely to add to the information requirement provisions in the DMCC. So for example, the proposals in the consultation are that reminder notice must be given in writing and on a durable medium, and the purpose of the notice must be immediately clear, and the prescribed information must be given up front, such as the first information that is seen by the customer. For cooling off notices, it is again proposed that they are sent in a durable medium, that is the primary purpose of the notice, but also that the cost of the returning goods is included in that notice so the customer is aware. Fifth, there's provision in the DMCC for the contracts that are excluded from the DMCC to be extended by regulation. Now, the current excluded contracts are found in Schedule 22 of the DMCC, and for anyone who's familiar with exclusions in consumer protection legislation, they're going to be reasonably familiar. So there's a carve-out for contracts such as utilities, insurance, financial services, Ofcom regulators, alike, as Sabrina mentioned earlier. But in respect to the financial services exclusion, rather than linking the exclusion to those activities that are currently regulated by the FCA, the exclusion in the DMCC uses the same language as is often found in other consumer protection legislation. So it defines context, financial services referring to context of a banking, credit, insurance, personal pension investment or payment nature. But unfortunately, this doesn't cover all FCA regulated activities. And in respect to subscription contracts, there's a specific issue with hire contracts, which at present are subject to FCA regulation, but would also appear to satisfy the definition of subscription contract, the DMCC, which has some real practical consequences, because traders may therefore be required to give customers differing cancellation rights under the two regimes. Whilst ordinarily I would not expect to see regulations extending exemptions from day one of implementation, because ordinarily you would assume the legislation gets it initially correct, and there's no mention of this in the consultation, I can see some possibility that we may see some movement from the regulations on excluded contracts. But one also note of caution, this is very much speculation on my part, and we need to wait for the regulation to see if this will happen. But on a practical note, if you currently carry on a hire business, you need to be preparing on the basis that your hire contracts might be in the scope of the subscription provisions. Finally, the consultation also makes proposals in some other areas as to what the regulations should include, such as rights to cancel for traders breach of the DMCC and precluding making customers liable for payments too early in order to avoid the effects of the cancellation provisions. As well as the regulations, we expect to see guidance from the Competition and Markets Authority. We wait to see that will say, but there is again some hint of what this may contain in the consultation. There's proposals that there's guidance setting out how customers can exit the contract and how the information requirements must be complied with in practice. And the former may be particularly important for traders that want to try and persuade their customers not to cancel their contracts. As Sabrina mentioned earlier, there's sort of rules and you can't make it too onerous for the customer to do so. So the consultation suggests that you can offer deals to try and entice customers to stay, but it can't be in a reasonable bar to the customer cancelling. So the guidance may say, for example, that you can require customer to cancel order, but you can't require them to sit in a telephone queue for an hour so that a representative can speak to them and put the deal to them. That's unlikely to be permissible. So what then can traders do now to prepare for these provisions? Well, as a starting point, we'd suggest you identify whether you have a subscription contract. The provisions are not entirely straightforward, and there is a risk that they may catch some traders unaware. But once a subscription contract has been identified, then initial steps towards compliance can be taken, such as determining when it is likely that notice will need to be provided, as Sabrina talked about earlier, and then assuring that systems are geared up to providing notice at those times. We can take a pretty good guess as to what might be included in the notices, and indeed certain of the information provisions are set out in the DMCC itself, so these are not going to change. But unfortunately, we can't you can't finalise the preparations until the regulations and the guidance are eventually published. And unfortunately, at the moment, we need to wait to see when this will happen. Well, that is it from Sabrina and myself. We hope you found this informative. And please keep an eye out for the date of our next Gov Square Live, which will be communicated in the usual manner. Thank you.
Thanks very much.